I was sitting on my porch in West Texas, sipping coffee at 6 in the morning, when I first noticed the surveyor trucks rolling down the dirt road that bordered my ranch property. This was March 2019, and I had owned these 847 acres outside of Lubbock for nearly 15 years. The land had been in my family since my grandfather bought it in 1952, back when cattle ranching was still profitable, and the oil boom had not yet transformed the landscape. Now I raised a modest herd of about 200 head, grew some hay, and mostly enjoyed the peace and quiet that came with rural life. The trucks kept coming for 3 days straight. I watched them through my binoculars, curious but not particularly concerned. There was a large tract of undeveloped land that ran along my eastern boundary, about 40 acres that had changed hands a few times over the years. I figured someone had finally decided to do something with it. Maybe a new ranch, maybe some kind of agricultural operation. I went about my business, checking fences, feeding cattle, and handling the daily routines that came with managing a property this size. Then the construction equipment arrived. Bulldozers, excavators, cement mixers, the whole 9 yards. I could see the dust clouds from miles away. By the end of the first week, they had cleared about half the neighboring property and started laying foundations. I still was not worried. Texas is a property rights state, and people can generally do what they want with their own land as long as it meets county regulations. I had enough distance between my house and the construction that noise was not much of an issue. But then something strange started happening. The construction crews began working on land that looked awfully close to my property line. I pulled out my survey maps, the ones I had gotten when I refinanced the ranch back in 2015, and studied them carefully. The eastern boundary was clearly marked, running along a natural creek bed that had been dry most years but occasionally flooded during heavy rains. According to my maps, the construction was definitely encroaching. I drove out to the site one morning in my pickup truck, bouncing along the rough terrain until I reached where the crews were working. A large sign had been erected near the road. Sunset Meadows Community 51 Luxury Duplexes, coming fall 2020, managed by Sunset Meadows HOA. Below that was contact information for a property management company based in Amarillo. I parked and walked over to where a man in a hard hat was reviewing blueprints with a couple of workers. He looked up as I approached, his expression neutral but professional. "Morning," I said, extending my hand. "I'm Jack Morrison. I own the ranch just west of here." He shook my hand firmly. "Dave Patterson, site foreman, nice to meet you." "I wanted to ask about your property boundaries," I said, keeping my tone friendly. "It looks like some of your construction might be crossing onto my land." Dave frowned and pulled out a rolled-up survey map from a tube he had been carrying. He spread it across the hood of a nearby truck and pointed to various landmarks. "According to this, we are well within our boundaries. See here. This shows the creek bed as the western edge of the Sunset Meadows property." I leaned in to look. The map he was showing me was dated February 2019, just a month before construction began. But something was off. The creek bed they had marked was about 300 yards east of the actual creek bed that formed my boundary. I pointed this out. "That dry wash you are calling a creek bed is not the property line," I explained. "The actual boundary is further west, along a deeper creek that runs north to south through this whole section. It has been the boundary since the original land grants in the 1800s. Dave looked uncomfortable. "I just follow the surveys I'm given." "If there is a boundary dispute, you would need to take that up with the property owners or the HOA management company. I have their information in my trailer if you want it." I took down the contact information and drove back to my house. That afternoon, I called the number for Sunset Meadows HOA management. A woman answered after 3 rings, her voice chipper and professional. Sunset Meadows HOA, this is Brenda speaking. How may I help you today? Hi Brenda, my name is Jack Morrison. I own the ranch property adjacent to your new development, and I think there might be a boundary issue. Some of your construction appears to be on my land. There was a pause. Sir, I can assure you that all of our surveys have been professionally completed and filed with the county. We would not be building if we did not have clear title to the land. I understand that, I said, trying to remain patient, but I have my own surveys and they show a different boundary line. I think someone made an error, and I would like to get it resolved before construction goes any further. Brenda put me on hold for nearly 10 minutes. When she came back, her tone had changed slightly, becoming more formal and less friendly. Sir, I spoke with our property manager, Karen Whitmore. She says that if you believe there is a boundary dispute, you need to file a formal complaint with the county and go through the proper legal channels. We cannot stop construction based on an informal complaint from a neighbor. I am not asking you to stop construction, I said, feeling my frustration rising. I am asking you to verify your boundaries before you build permanent structures on land that does not belong to you. As I said, sir, we have followed all proper procedures. If you have concerns, you need to address them through official channels. Is there anything else I can help you with today? I hung up, irritated but not defeated. I called my attorney, a guy named Bill Henderson who had handled various legal matters for me over the years. Bill had been practicing law in Lubbock since the 1980s and knew property law inside and out. I explained the situation, and he agreed to look into it. 3 weeks later, Bill came out to the ranch with his own surveyor. We walked the property line together, using GPS equipment and comparing it to the historical records from the county clerk's office. The results were exactly what I had suspected. The Sunset Meadows development had placed their construction approximately 300 yards onto my property. Not just a little encroachment, but a massive overlap that included the foundations for at least 12 of the planned duplexes. This is a significant problem, Bill said, shaking his head as we stood looking at the construction site in the distance. They either used a bad survey or deliberately ignored the correct boundaries. Either way, they are building on your land without permission. What are my options? I asked. Bill thought for a moment. The standard approach would be to file an injunction, stop construction immediately, and force them to tear down whatever they have built on your property. That would be the quickest resolution. But, I could hear the hesitation in his voice, but there might be another angle here. If they complete construction on your land, essentially building improvements on property they do not own, you could have a claim for unjust enrichment, or potentially even collect rent for the use of your land. It is a riskier strategy, and it would take longer, but the financial outcome could be much more favorable. I looked out at the construction site. Crews were working steadily, pouring concrete and framing walls. Trucks came and went constantly. They were moving fast, probably trying to meet their fall 2020 deadline. How much more favorable are we talking about? I asked. Bill pulled out a calculator and started running numbers. If they build 12 duplexes on your land, that is 24 residential units. In this market, rental value for a duplex unit would be somewhere around $800 to $1,000 per month. Let's say $900 to be conservative. That is 24 units times $900, which is $21,600 per month. If you let them finish construction, rent the units, and operate for a couple of years before you bring the hammer down, you could be looking at several $100,000 in back rent, plus the value of the improvements they built on your land. I felt my heart rate pick up. Several $100,000 was real money, even for someone with assets like a ranch. It could pay off the remaining mortgage, fund some much-needed equipment upgrades, and provide a comfortable cushion for retirement. What are the risks? I asked. The main risk is that a court might not see it your way. They could argue that you should have stopped construction immediately, and by waiting, you essentially gave permission. There is also adverse possession to consider, though that takes 10 years in Texas, so that is not an immediate concern. The other risk is that they might not have the money to pay you even if you win in court. I thought about it for a long moment. The HOA had been rude and dismissive when I tried to address the issue directly. They had not even bothered to double-check their boundaries when I raised concerns. And now Bill was telling me that I could potentially turn their arrogance into a significant financial windfall. "Let's document everything," I said finally. "I want photographs, updated surveys, everything we need to prove that I knew about this and that they were clearly on my property. But let's not file the injunction yet. I want to see how this plays out." Bill looked at me carefully. "Jack, I need to make sure you understand what you are getting into. This could take years to resolve. You are going to have to watch them build on your land, watch people move in and not say anything. It is going to be frustrating." "I understand," I said, "but they had their chance to do this right. They chose not to listen. Now they can deal with the consequences." Over the next 18 months, I watched Sunset Meadows rise from the dusty Texas soil. The construction was impressive, I had to admit. The duplexes were well built, modern structures with fiber cement siding, energy-efficient windows, and attached garages. Each building housed 2 separate units, and they arranged them in neat rows with landscaped common areas in between. They installed a community pool, a small clubhouse, and even a playground. I documented everything. I took photographs every week, showing the progress of construction. I kept copies of all the advertising materials that Sunset Meadows HOA distributed, showing the site plans and which units were built where. I had Bill's surveyor come out every few months to update the GPS records and confirm exactly which structures were on my property. By my count, they had built 13 full duplexes on my land, slightly more than the original 12 that Bill had estimated. That meant 26 residential units sitting on property that belonged to me. The rest of the development, another 38 duplexes, sat on land that legitimately belonged to the Sunset Meadows HOA. The development opened for occupancy in October 2020, just slightly behind their original schedule. I drove by the grand opening event, watching families tour the model units and sign leasing agreements. Karen Whitmore was there, a woman in her early 50s with blonde hair styled in an aggressive bob, wearing a pantsuit that probably cost more than most people's monthly rent. She stood near the entrance, greeting potential residents with a broad smile and a firm handshake. I kept my distance, watching from my truck. There would be time enough for confrontation later. The first residents started moving in by November 2020. I watched the moving trucks come and go, families carrying furniture and boxes into their new homes. Kids played in the common areas. People walked their dogs along the newly paved streets. It looked like a thriving little community. I continued my documentation. I started keeping a log of which units were occupied and when. I noted license plate numbers in case I needed to track down tenants later for testimony. I photographed the rent signs that went up, advertising units for $950 per month for a 2-bedroom duplex. That was slightly higher than Bill's estimate, which was good for my eventual claim. The HOA began operating in full force by early 2021. They sent out newsletters to residents, organized community events, and started enforcing their rules with the kind of zealous enthusiasm that gives homeowners associations a bad reputation. I heard stories from some of the residents who would occasionally wander onto my ranch property. not realizing where the actual boundary was. They complained about fines for parking violations, restrictions on what color they could paint their front doors, and rules about when they could put out their trash cans. Karen Whitmore ran the HOA like a fiefdom. I learned more about her through my observations and through conversations with residents who did not realize I had a stake in their community. She had been in HOA management for over 20 years, working with various communities around the Texas Panhandle. She had a reputation for being strict but effective, the kind of person who kept communities looking pristine even if it meant alienating half the residents. One afternoon in March 2021, I was fixing a fence line near the border between my ranch and Sunset Meadows when a woman approached me. She was in her 30s, wearing yoga pants and a sweatshirt, walking a golden retriever on a leash. "Excuse me," she called out. "Are you the rancher who owns this property?" I straightened up, wiping sweat from my forehead. "Yes, ma'am, Jack Morrison, this is my land." She smiled, and her dog immediately tried to jump on me, tail wagging frantically. She pulled him back. "Sorry about that. I'm Michelle. I live in one of the duplexes just over there." She pointed to a unit that was definitely on my property, though she had no way of knowing that. "Nice to meet you," I said. "How are you liking Sunset Meadows?" She made a face. "The duplex is great, the location is perfect, but the HOA is driving me insane. I got a $50 fine last week because my trash can was visible from the street for more than 2 hours after pickup. I was at work. What am I supposed to do, take a day off to move my trash can?" I shook my head sympathetically. "That does sound frustrating." "And that is not even the worst part," she continued, clearly needing to vent. "Karen, the HOA president, she walks around like she owns the place. She was actually measuring people's grass last month to make sure it was not over 3 inches tall. Who does that?" "Someone with too much time on her hands," I suggested. Michelle laughed. "Exactly. Anyway, I saw you out here and just wanted to introduce myself. Some of us were wondering about the ranch." "Do you ever give tours or anything?" "Not generally," I said, "but you are welcome to walk along the fence line if you want. Just be careful of the cattle." She thanked me and headed back toward her duplex. I watched her go, thinking about the 26 units worth of residents who had no idea they were living on disputed property. I felt a twinge of guilt. These were regular people, just trying to live their lives, and they were going to get caught in the middle of a legal battle that was not their fault. But then I reminded myself that I had tried to address this issue before construction even started. I had called the HOA, expressed my concerns, and been brushed off. Karen Whitmore and her organization had made their choice. Now they would have to live with the consequences. By summer 2021, all 26 units on my property were occupied. I calculated the monthly rental income at $950 per unit, which came to $24,700 per month. That was nearly $300,000 per year in rent being collected on my land without my permission. The numbers were staggering. I met with Bill regularly to discuss strategy. He had been researching similar cases and building our legal approach. The key, he explained, was proving that the HOA either knew or should have known that they were building on my property. We had my phone call to Brenda, which she had hopefully logged in their system. We had the survey discrepancies, and we had the historical records showing the true boundary line. "The question is when to file," Bill said during one of our meetings in July 2021. "We could file now and seek back rent for the 8 or 9 months the units have been occupied. Or we could wait longer and increase the damages. What makes more sense legally?" I asked. "Honestly, waiting longer strengthens your case in some ways. It shows a clear pattern of ongoing trespass and unjust enrichment. It also gives them more time to potentially discover the error themselves, which they clearly have not done. But it also increases the risk that something could go wrong." I thought about it. Let's give it until 2022, 3 years of construction and operation. That seems like a reasonable timeline to show that this was not just an innocent mistake, but a systematic problem. Bill nodded. 3 years works. That would put us at March 2022 for filing, which gives us the spring and summer for discovery and depositions, potentially going to trial in late 2022 or early 2023. So I waited. I continued running my ranch, taking care of my cattle, and watching Sunset Meadows thrive on my stolen land. It was strange, living with this secret knowledge that eventually everything was going to come crashing down for them. I sometimes felt like a chess player watching my opponent make a series of devastating moves without realizing they had already lost the game. The HOA continued their aggressive management style. I heard more stories from residents about unreasonable fines and arbitrary rule enforcement. Karen Whitmore seemed to delight in her authority, sending out violation notices for the most minor infractions. A child's bike left on a front lawn overnight. A package sitting on a doorstep for more than 24 hours, Christmas decorations that stayed up past January 1st. In November 2021, the HOA actually sent me a letter. It arrived in my mailbox, an official-looking envelope with the Sunset Meadows logo. I opened it with curiosity. The letter was from Karen Whitmore herself. It informed me that several Sunset Meadows residents had been allowing their pets to wander onto adjacent properties, and that the HOA was working to prevent this. However, they had noticed that my ranch property lacked adequate fencing along the border with their community, and they requested that I install appropriate barriers to keep my cattle from disturbing their residents. I read the letter 3 times, amazed at the audacity. They had built on my land without permission, and now they were asking me to put up fences to protect their residents from my legitimate agricultural operations. The irony was almost too much. I called Bill and read him the letter. He laughed so hard I thought he might hurt himself. "Keep that letter," he said when he finally caught his breath. "That is going to be gold in court. They are essentially admitting that they know about your property and are trying to dictate what you do with it." I filed the letter carefully with all my other documentation. Every piece of evidence was one more nail in the HOA's coffin. By December 2021, I started preparing more seriously for the lawsuit. Bill hired a forensic accountant to help calculate the exact damages we would be seeking. We needed to determine not just the rental income from the units on my property, but also the fair market value of the land use, any appreciation in property values, and potential punitive damages. The accountant, a meticulous man named Robert Chen, spent weeks analyzing comparable properties, rental rates, and land values. He produced a detailed report that estimated the total damages at just under $900,000. That included back rent for the occupied units, the value of land use during construction, and a reasonable markup for the unauthorized nature of the use. $900,000, I said, staring at the number. It was more money than I had ever imagined seeing at one time. "That is the conservative estimate," Robert explained. "If you factor in punitive damages for willful trespass, you could potentially see that number increase significantly. But this is what I would feel comfortable testifying to in court." I authorized Bill to move forward with filing the lawsuit. We scheduled it for March 2022, almost exactly 3 years after I had first noticed the surveyor trucks on that early morning in 2019. The paperwork was filed on March 15, 2022. The lawsuit named the Sunset Meadows HOA, the property management company, and Karen Whitmore personally as defendants. We alleged willful trespass, unjust enrichment, and conversion of property. We sought the $900,000 in damages, plus legal fees and court costs. The reaction was immediate and dramatic. Within days, I received a phone call from an attorney representing the HOA. His name was Marcus Webb, and he sounded both angry and confused. Mr. Morrison, I am calling regarding the lawsuit you filed against my clients. I have to say, this is highly irregular. If you believed there was a boundary dispute, why did you not raise this issue 3 years ago before construction began? I did raise it, I said calmly. I called your clients in March 2019, spoke to someone named Brenda, and explained that construction appeared to be encroaching on my property. I was told to file a formal complaint through official channels, which I chose not to do at the time, but that does not give your clients the right to build on my land. There was a long pause. You are claiming that you intentionally allowed construction to proceed, knowing it was on your property, just so you could collect damages later. I am claiming that your clients were notified of a potential boundary issue, chose to ignore it, and proceeded to build on my land without permission or compensation. The fact that I chose not to stop them does not make their actions legal. Marcus's voice took on a harder edge. Mr. Morrison, I am going to be very direct with you. This looks like a setup. This looks like you deliberately allowed my clients to invest millions of dollars in construction, so you could swoop in later with a lawsuit. No judge is going to look favorably on that kind of behavior. Then I guess we will let a judge decide, I said. I look forward to seeing you in court. I hung up before he could respond. My hands were shaking slightly. This was really happening. 3 years of planning and waiting, and now we were finally going to get resolution. The legal process moved slowly, as these things always do. Discovery began in April 2022, with both sides requesting documents and scheduling depositions. Bill subpoenaed all of the HOA's records related to the property purchase, surveys, and construction. We wanted to see every communication, every document, every piece of evidence that showed what they knew and when they knew it. The HOA's defense strategy became clear fairly quickly. They argued that their survey had been conducted by a licensed professional and filed with the county, and they had relied on it in good faith. They claimed that any boundary error was the fault of the surveyor, not the HOA. And they argued that by waiting 3 years to file suit, I had essentially waived my rights to object. My deposition was scheduled for June 2022. I drove to Marcus Webb's office in Amarillo on a hot Tuesday morning, dressed in slacks and a button-down shirt. Bill accompanied me, briefing me on what to expect. Answer the questions honestly and directly, he advised. Do not volunteer extra information. If you do not know something, say you do not know. And stay calm, no matter how much Marcus tries to provoke you. The deposition room was small and stuffy, with a conference table and a court reporter set up to record everything. Marcus Webb sat across from me, looking professional in an expensive suit. Karen Whitmore sat next to him, her expression a mixture of anger and disbelief. Marcus started with basic background questions about how long I had owned the ranch, what I used it for, and my general knowledge of property boundaries. Then he moved to the critical issue. Mr. Morrison, when did you first become aware that Sunset Meadows might be building on your property? Late March or early April 2019, I answered. I noticed construction equipment that appeared to be working close to my property line. And what did you do when you noticed this? I drove out to the construction site and spoke with the foreman, Dave Patterson. I explained my concern about the boundaries. What did Mr. Patterson say? He said he was following the survey he had been given and that if I had concerns, I should contact the HOA management company. And did you contact them? Yes. I called the number I was given and spoke with a woman named Brenda. I explained that there might be a boundary issue and that some construction appeared to be on my land. Marcus leaned forward. And what was Brenda's response? She put me on hold and then came back and said that if I had concerns, I needed to file a formal complaint through official channels. She said they had followed all proper procedures and would not stop construction based on an informal complaint. But you did not file a formal complaint, did you? No, I did not. Why not? I paused, choosing my words carefully. I consulted with my attorney, Bill Henderson. He advised me of my legal options. I made a decision to document the situation and pursue damages rather than seek an immediate injunction. Marcus looked satisfied, like I had just admitted to something damaging. So you deliberately allowed construction to continue, knowing it was on your property, so you could sue for more money later. Bill started to object, but I held up a hand. I allowed construction to continue because your clients chose to ignore my warning about a boundary dispute. I had no legal obligation to stop them from trespassing on my property. That was their responsibility, not mine. You had a moral obligation, Marcus shot back. That is not a legal standard, I replied calmly. The deposition went on for 3 more hours. Marcus asked me detailed questions about every conversation I had had, every piece of documentation I had collected, and every decision I had made. I stuck to the facts and did not let him rattle me. Karen Whitmore was practically vibrating with rage by the end of it. As we were packing up to leave, she stood and pointed a finger at me. "You are a con artist," she hissed. "You set us up. You deliberately let us build so you could steal our property." "I think you have that backwards," I said quietly. "You built on my property. I am just asking to be compensated for it." She looked like she wanted to say more, but Marcus put a hand on her arm and guided her out of the room. Bill and I followed a few minutes later. "That went well," Bill said once we were in his car. "You stayed calm, you answered honestly, and you did not give them anything they can use against us. Marcus is going to have a hard time making you look like the bad guy here. What happens next?" I asked. Depositions for their side. I want to talk to Karen, to whoever conducted their survey, and to anyone else involved in the decision to build. Then we wait for a trial date. The HOA's depositions happened throughout the summer of 2022. The surveyor who had conducted their boundary assessment admitted under oath that he had made an error. He had used the wrong creek bed as a reference point and had not adequately researched the historical property records. It was a significant mistake, but he maintained that it was an honest one. Karen Whitmore's deposition was contentious. Bill pressed her on why she had not taken my concerns seriously in 2019, why she had not ordered a second survey to verify the boundaries, and why the HOA had sent me a letter in 2021 essentially telling me how to manage my own property. "We relied on professional advice," she kept repeating. "We had no reason to believe our survey was incorrect. But Mr. Morrison told you directly that he believed construction was on his land," Bill pointed out. "You could have spent a few $1,000s on a verification survey. Instead, you gambled that he was wrong, and you lost." By October 2022, both sides had completed discovery, and the case was scheduled for trial in January 2023. Bill felt confident about our chances, but he warned me that juries could be unpredictable. "The HOA is going to paint you as a greedy landowner who took advantage of an honest mistake," he said. "We need to show that you acted reasonably, that you tried to warn them, and that they chose to ignore you. The fact that you waited 3 years is going to be the central issue." As the trial date approached, I found myself thinking more about the residents of Sunset Meadows. 26 families were living in units that might become subject to some kind of legal remedy. I did not want to evict people or cause hardship for innocent tenants. My fight was with the HOA, not with the people who had simply rented homes. I talked to Bill about it. "If we win, what happens to the residents?" "That depends on the remedy the court orders," he said. "In theory, the HOA would have to pay you the back rent and potentially relocate the structures, or buy the land from you at fair market value. The residents would not be affected unless the HOA fails to comply with the court order. I do not want to kick people out of their homes, I said. Then we make sure the settlement includes provisions for the residents. We can structure it so that the HOA has to compensate you financially, but the residents can stay. That would probably require the HOA buying that portion of your land at a premium, which honestly might be the most realistic outcome anyway. The trial began on January 9, 2023, in the Lubbock County District Court. Judge Patricia Hernandez presided, a no-nonsense woman in her 60s with a reputation for being fair but demanding. The jury consisted of 8 people, a mix of ages and backgrounds, all of whom looked skeptical about the whole situation. Bill delivered our opening statement, laying out the facts clearly. He explained how I had noticed the construction, how I had tried to warn the HOA, and how they had ignored my concerns. He walked through the documentation showing exactly which units were built on my property and how much rent had been collected. He emphasized that this was not about a simple mistake, but about an organization that had chosen expediency over due diligence. Marcus Webb gave the defense's opening statement, painting me as a manipulative landowner who had deliberately set a trap. He argued that any reasonable person would have stopped construction immediately if they truly believed their property was being violated. He said I had essentially created the damages I was now seeking to collect. The trial lasted 2 weeks. Bill called me to testify, and I spent a full day on the stand walking through everything that had happened. I explained my conversations with the foreman and with Brenda. I showed the photographs and surveys documenting the encroachment. I discussed my decision to consult with an attorney rather than immediately seeking an injunction. Marcus cross-examined me aggressively, trying to make me seem calculating and dishonest, but I stuck to the truth. I had warned them. They had chosen not to listen. I had every right to seek compensation for the unauthorized use of my land. Bill called the surveyor who had made the original error. The man was clearly uncomfortable, admitting that he should have been more thorough in his research. He had relied on outdated county records and had not verified them against historical documents. Karen Whitmore testified for the defense, insisting that the HOA had acted in good faith throughout. But under Bill's cross-examination, she admitted that she had not ordered a second survey after I called in 2019. She admitted that the HOA had sent me a letter in 2021 essentially acknowledging my property, but asking me to modify it for their benefit. Each admission chipped away at her credibility. The most powerful testimony came from Robert Chen, our forensic accountant. He walked the jury through his analysis, showing exactly how much rental income had been collected from units on my property. He presented comparable land values and rental rates. His numbers were conservative and well documented. By the time he finished, it was clear that the HOA had benefited substantially from the use of my land. In his closing argument, Bill reminded the jury that property rights were fundamental to American law. He emphasized that I had tried to warn the HOA, that they had ignored me, and that they had profited from my land for nearly 3 years without compensation. He asked the jury to award the full $900,000 in damages. Marcus gave an impassioned closing for the defense, arguing that I had acted in bad faith by allowing construction to proceed. He asked the jury to consider what a reasonable person would have done and to reject what he called my calculated scheme. The jury deliberated for 2 days. On January 26, 2023, they returned with a verdict. I sat in the courtroom, my heart pounding as the foreman stood to read it. We, the jury, find in favor of the plaintiff, Jack Morrison, on all counts. I felt Bill's hand on my shoulder, squeezing gently. We had won. The foreman continued reading. The jury awarded me $820,000 in damages, slightly less than what we had requested, but still a substantial amount. They had apparently decided to give the HOA a small break on some of the calculations, but the message was clear. I was entitled to compensation for the unauthorized use of my land. Judge Hernandez thanked the jury and scheduled a hearing for the following week to discuss the logistics of the judgment. As we left the courtroom, I could see Karen Whitmore in tears, surrounded by other HOA board members who looked shell-shocked. The hearing the following week focused on how the judgment would be satisfied and what would happen to the residents. Marcus argued that the HOA could not possibly pay $820,000 without selling assets, potentially including the duplexes that sat on my land. Bill proposed an alternative. The HOA could purchase the land where their structures sat, approximately 13 acres, for fair market value plus a premium. Combined with the back rent award, this would require them to pay me about $1.2 million total, but it would allow the residents to stay and would give the HOA a path forward. Judge Hernandez liked this solution. She gave the HOA 90 days to either pay the full judgment or reach a settlement agreement with me that included purchasing the land. If they failed to do either, she would order the structures removed from my property and would authorize additional collection efforts. Over the next month, Marcus and Bill negotiated a settlement. The HOA agreed to pay me $950,000, which covered the back rent, the land purchase, and legal fees. In exchange, I would deed over the 13 acres containing their structures, and the residents would be able to stay without disruption. The payment came through in April 2023, deposited into my account in a lump sum that made my bank's fraud detection system flag it for review. I had to go into the branch in person to confirm that, yes, this was a legitimate transaction. With the settlement finalized, I paid off my ranch mortgage completely. I invested a significant portion of the remaining money in a diversified portfolio. I used some to upgrade equipment and make improvements to the ranch. And I set aside a comfortable emergency fund that would let me weather any future problems. The story made local news, and then regional news, and eventually got picked up by some national outlets as a quirky legal interest piece. I gave a few interviews, though I tried to keep a low profile. I was not interested in being famous. I just wanted fair compensation for what had happened. Karen Whitmore resigned from the HOA in May 2023. I heard through the grapevine that she had moved to Arizona and gotten out of property management entirely. The HOA brought in new leadership, people who seemed more focused on serving residents than enforcing arbitrary rules. The community became noticeably more relaxed. I still see some of the residents occasionally. Michelle, the woman with the golden retriever, waves when she walks near my fence line. Some of them know the full story now, though most just know that there was a legal dispute that got resolved. They seem content to stay, and I am glad they were not displaced by all of this. Looking back, I sometimes wonder if I should have handled things differently. Maybe I should have filed the injunction in 2019 and stopped construction immediately. It would have been simpler, cleaner, less complicated. But then I remember that phone call with Brenda, the dismissive way she had blown off my concerns. I remember Karen Whitmore's letter telling me to modify my own property for their convenience. I remember 3 years of watching them profit from land they did not own. No, I think I made the right choice. Property rights matter. Due diligence matters, and when someone tries to take what is yours, you have every right to hold them accountable. The ranch is quieter now, though I can still hear the sounds of the Sunset Meadows community in the distance when the wind is right. Kids playing, dogs barking, the normal sounds of suburban life. It is a reminder of how everything turned out, of how a simple boundary dispute became a 3-year chess match that ended with justice being served. I am 56 years old now, and I plan to keep running this ranch for another decade at least. The cattle are healthy, the land is productive, and I have the financial security to invest in the future. My grandfather would be proud, I think. He taught me that land is precious, that you fight for what is yours, and that patience and preparation can overcome almost any challenge. Every morning, I still sit on my porch with my coffee, looking out over the acres that have been in my family for generations. The surveyor trucks are long gone. The construction equipment is gone. What remains is the land itself, enduring and valuable and mine. And 13 acres that used to be mine, now legitimately belonging to Sunset Meadows HOA, purchased at a premium that reflected both its value and the cost of their mistake. It is a reminder that stands visible on the horizon, a collection of neat duplexes housing families who have no idea they are living in the middle of what became one of the strangest property disputes in Lubbock County history. The legal community still talks about the case sometimes. Bill told me it is being used in some property law classes as an example of the complexities around trespass, unjust enrichment, and the duty to mitigate damages. Apparently, there is legitimate debate about whether I acted appropriately or whether I should have been required to stop construction immediately. I do not have a strong opinion on the academic arguments. I just know how it turned out for me. The money has changed my life in practical ways, but not in fundamental ones. I still get up early, still check on the cattle, still fix fences and maintain equipment. But now I do it without the stress of worrying about every financial decision. When a truck needs replacing, I replace it. When a section of fence needs upgrading, I upgrade it. That kind of security is worth more than any amount of money in the bank. I have thought about expanding the ranch, maybe buying adjacent property if it becomes available. But I am also content with what I have. Sometimes more is not better. Sometimes you just need to take care of what is already yours. The relationship between my ranch and Sunset Meadows has settled into something peaceful. We are neighbors now, legitimately and legally. The boundary is clearly marked, properly surveyed, and undisputed. They stay on their side, I stay on mine, and everyone is satisfied with the arrangement. I heard that the new HOA leadership actually uses my case as a cautionary tale when they are considering any major projects. They verify everything, check multiple sources, and never ignore concerns raised by neighbors. It is amazing what a $1 million lesson will teach you. Sometimes on summer evenings, I drive my truck along the perimeter of my property, following the fence line that now clearly separates my ranch from their development. I look at those 13 duplexes and think about the families inside, living their lives, completely unaware of the complex legal battle that once swirled around them. They are innocent in all of this, just people looking for a place to live. The case officially closed in June 2023 when the final paperwork was filed with the county clerk. The deed transfer was recorded, the judgment was satisfied, and all parties signed releases confirming that the matter was fully resolved. It was anticlimactic in a way, years of tension and conflict reduced to a stack of legal documents in a filing cabinet. But the impact lingered. Bill Henderson still calls me every few months to check in and to tell me about other attorneys who have asked him about the case. He has given presentations at legal conferences about property disputes and the strategies involved. I think he is proud of the work he did, and he should be. He gave me excellent advice and executed the strategy flawlessly. As for me, I am just a rancher who stood up for his property rights and got a fair outcome. I did not set out to make legal history or to collect a $1 million settlement. I just wanted what was mine to be respected, and when it was not, I took appropriate action. The Texas landscape stretches out around me, endless sky and rolling prairie, cattle grazing peacefully in the distance. This land has survived drought and flood, economic boom and bust, generations of owners who tried to make a living from its stubborn soil. It will be here long after I am gone, passing to whoever comes next with its own stories and its own challenges. For now, though, it is mine. Every acre, every fence post, every blade of grass. And nobody, not even the most aggressive HOA in the Panhandle, can take that away without paying the price.